It's great to see so many people interested in the Sentencing Council's work. Today, we have a panel made up of Sentencing Council members who will be discussing our work on developing a guideline for the courts on sentencing young people. I'll introduce the panel, who are Lady Dorrian, the Lord Justice Clerk, and who is also Chair of the Council. Sheriff Principal Craig Turnbull. He is Chair of our Sentencing Young People Committee and the Committee on the Sentencing Process Guideline. Summary Sheriff Paul Brown. He sits in Glasgow and Strathkelvin, and he is Chair of our Communications Committee. David Harvie, Crown Agent and Chief Executive of COPFS. He's a member of our Sentencing Young People Committee and Chair of our Death by Driving Guideline Committee. We had hoped that Leslie Webber, who is Head of Effective Practice at the Risk Management Authority and the Council's Victims Expert member, would be taking part in the workshop, but sadly she's unavailable this morning. The panel discussion is going to be recorded, but we'll turn recording off after the panel discussion, so nobody will be recorded during the Q&A afterwards. I understand that CYCJ are going to be placing the recordings online and that they've informed everyone of this in advance, but if you have any concerns at all about being recorded, please just turn off your video and mute yourself during the session. The panel will be taking questions after the discussion piece, but feel free to ask any questions in the chat bar to the side. It's quite helpful to preface it with a Q so we can distinguish it from a comment. If you want to ask a question in person over the video, please just type in Q and then I'll ask you to pose the question yourself. If you have any technical troubles, just email us or pop something in the chat. We'll do our best to help. And with that, I'll hand over to Lady Dorrian to begin the panel discussion. I think you're muted.
Sorry about that. I'd muted to prevent any background noise affecting Ondine there. So good morning all, and welcome to this workshop on sentencing and the rights of children and young people. Each of our panel members will give a short talk on one aspect of the Council's work on children and young people, and then we'll be very happy to take any questions. First, I'll give you some context for the workshop. It's almost 2 years to the day since I spoke about the development of our guideline on the sentencing of young people to the last National Youth Justice Conference. At that stage, I fully expected that the guideline was going to be finalised and submitted to the High Court for approval last year, and that it would have been enforced by now. But as we all know, the pandemic has brought about an unprecedented level of disruption that has affected all of us, both professionally and personally. So it's taken time to find ways to overcome the challenges posed by that and adjust to new ways of working, and that's affected Council work as much as anybody else's. Let's hope that the worst is behind us. From the Council's point of view, there is now distinct cause for optimism. We're on the verge of finalising 2 sentencing guidelines, one on the sentencing process, the general process of sentencing, and the other on sentencing young people. This will be something of a milestone for us, and I would suggest a milestone for the treatment of children and young people in Scotland. This represents for the Council not only the completion of 2 key commitments in our 2018 to 21 business plan, it marks the end of our first phase of work. Since we were established in 2015, our main focus has been on completing a suite of general guidelines to set out a high-level framework for sentencing in Scotland applying to all offences. The principles and purposes of sentencing guideline, our first one, came into force in November 2018 and sets out a core principle of fairness and proportionality, which we consider underlies all sentencing decisions. It also outlines purposes which sentencing may seek to achieve, which may be rehabilitation, it may be protection of the public, it may be punishment, there may be others. we today published our report on the consultation on the sentencing process guideline, which sets out our final decisions in respect of that guideline, which will shortly be submitted for approval. That guideline sets out the various steps taken and some of the factors which get taken into account by judges in making a sentencing decision. And this will be the first time that they've been expressly defined in one single document in Scotland. These two general guidelines will apply to every sentencing decision in every criminal court in Scotland. They will also apply to young people being sentenced in Scotland, whatever the offence. But in addition to that, the Sentencing Young People Guideline is a general guideline that will apply to all offences where the person being sentenced is a young person. It sets out the ways in which sentencing of a young person is a different exercise from sentencing an older person. For example, it explains why rehabilitation should be and is a primary consideration for a young person, and why a young person's intellectual and emotional maturity should be considered when assessing their level of blame for any offending. We held a public consultation exercise on the guideline last year, and we've recently finished considering the responses. We'll be making an announcement about our final decision on the content of the guideline in mid-July, and intend to submit it to the High Court for approval later in the summer. It was interesting to note that the responses to the consultation highlighted diverging views between organisations on the one hand and individuals on the other. So, for example, many individuals took issue with our proposal to define a young person as someone under the age of 25. However, the consultation exercise, didn't in fact reveal any research that called into question the evidence on cognitive development drawn on by the Council in preparing the guideline. On the other hand, organisations were nearly unanimous in their support for this proposal and for other aspects of the guideline. So we have taken account of views expressed on certain aspects of the draft guideline, as we would always do, but we remain committed to taking an evidence-based approach to the development of all our guidelines. The Sentencing Young People Guideline will explain why a young person should be sentenced differently from a fully mature adult, and sets out the overarching principles to be followed when sentencing, including that the best interests of the young person should be considered in every case and must be a primary consideration when the young person is under 18, in accordance with the UN Convention on the Rights of the Child. The Sentencing Process Guideline will also bring benefits to the sentencing of children and young people. Although on the face of it, it's purely a technical guideline, and some people might think that, it will be of huge importance in explaining sentencing to the public, to victims, and to those who have been convicted. We've taken advantage of the delays caused by the pandemic to make sure that this guideline interacts very clearly with the Sentencing of Young People Guideline, particularly in respect of how courts should assess the seriousness of the offence, including the impact on any victims. So taken together, our first three guidelines will promote consistency in approach and help to explain to the public how sentencing decisions are made. They'll also provide the foundation for the next phase of our work when we turn to look at specific offence guidelines. That doesn't mean, of course, that we consider our work on children and young people to be done. Among the first of our offence guidelines will be guidelines on rape, sexual assault and indecent images, which are offences in which children or young people may sadly be involved, either directly as perpetrator or as victim, or indirectly as witnesses. These are highly complex areas which present particular challenges to sentencers, and it's imperative that the development of these guidelines is informed by research and engagement involving children and young people and the groups and organisations who work with and represent them. So with that slight overview of where we are at the moment in the work of the Council, I'd like to invite Sheriff Principal Craig Turnbull to speak about some of the work underpinning the Sentencing Young People Guideline and some recent in-court developments in that context. So over to you, Craig.
Thank you very much, Lady Dorrian. Good morning, ladies and gentlemen. The approach the Council has chosen to adopt in relation to the development of sentencing guidelines is in many ways similar to the development of legislation. A significant amount of research and consultation is required. And that's because the impact of proposing a guideline which has not been properly considered and tested would be considerable. Even small changes in sentencing practice could have significant consequences, both for those involved in individual cases and for the criminal justice system as a whole. In developing guidelines, the Council has drawn on expertise and research from across Scotland and other jurisdictions and undertaken a wide range of consultation activity. In the development of the Sentencing Young People Guideline, the Council regarded it as essential that the views of young people were obtained, both on sentencing in general and on early drafts of the guideline. The development process began in April 2017 with a stakeholder conference to consider possible approaches to the guideline. This brought together organisations and individuals from across the justice system and beyond, including organisations with expertise in young people affected by the justice system, victim support groups, academics and judges. The Council then carried out research involving focus groups to examine the public's views on youth offending and sentencing. A number of the participants in this research were aged between 18 and 24, including some who identified as coming from Black or minority ethnic backgrounds. In 2018, the Council commissioned a literature review of youth offending and sentencing in Scotland and other jurisdictions, which examined the available research on this subject. The review highlighted a number of matters which the Council took into account in drafting the guidelines, such as research on the stages of brain development, evidence of the high number of young people who have offended who have had adverse childhood experiences or experiences of trauma, and research about the sentencing approaches which might be most effective in reducing reoffending. Developing the guideline has been an iterative process, and the Council has sought the views of the judiciary throughout. This included seeking views on an early draft of the guideline and carrying out judicial testing on later drafts. In October 2019, the Council held a consultation workshop with 22 members of the Scottish Youth Parliament, in which we sought their views about some key aspects of the draft guideline. This was preceded by an online survey organised for the Youth Parliament, which included 2 of the questions discussed at the workshop. Just over 800 young people took part in the survey. We consider the outcomes of those exercises when preparing materials for the launch of the public consultation last year. Of great importance in informing our thinking was a systematic review of the latest evidence concerning brain development and its relevance in judicial contexts, which we commissioned in the second half of 2019. This was a study of studies from around the world rather than a singular investigation, and was carried out on behalf of the Council by Edinburgh University. Among other things, it highlighted compelling evidence that the brain does not fully mature until at least the age of 25. Now, we've taken the findings of the review into account in defining who should be considered a young person under the guideline. In order to obtain the views of young people on the themes and issues addressed in the draft guideline, the Council also commissioned the University of the West of Scotland to carry out focus groups with young people across Scotland. This work was carried out between July 2019 and January 2020. It included young people who had experience of the criminal justice system, either through being convicted of a crime or as the victim of a crime. The findings suggest that the young people who took part in the focus groups were largely in agreement with the provisions in the draft guideline, and we intend to publish the reports on this research on our website in a few weeks' time. Unfortunately, the pandemic prevented us from carrying out further direct engagement with young people in detention or secure care as we had hoped to do. Perhaps the most significant part of the development process was the public consultation exercise last year, which David Harvie will say a little bit more about later. During the public consultation, we carried out direct engagement with the Victims Organisations Collaboration Forum Scotland and 9 separate victims and survivors organisations. The views expressed in those discussions were taken into account in the final decisions about the content of the guideline. It's impossible to summarise the findings of all of this activity in the time available today, but I think it's fair to say that some key themes emerged. While there was no generally agreed definition of a young person, it was generally accepted that evidence of the brain continues to develop until at least 25 should be taken into account in sentencing. Courts should consider the role of trauma and adversity in offending behaviour by young people, including how this has affected their maturity. And rehabilitation should be seen as a key goal in sentencing young people. However, as the Lord Justice Clerk mentioned earlier, the views of most of the individuals who responded to the public consultation differed from this. And again, this is something that David Harvie will talk about later. But the Council's view is that the approach we propose in the guideline reflects the findings of our research and engagement. It also aligns with recent developments in Scotland and elsewhere. The Scottish Government proposes to raise the age of referral to the principal reporter on offence grounds to include all under 18s. Yesterday, the new Youth Justice Vision and Priorities prepared by the Scottish Government and the Youth Justice Improvement Board was announced. It will involve extending the whole system approach to those under 26. The National Probation Service in England and Wales now assesses the maturity of offenders up to age 25 in pre-sentence reports. And the Irish Government has announced in its Youth Justice Strategy 2021 to 2027 that it will look at steps to increase the age limit for its youth diversion scheme from 18 to 24. Another development that I can talk about with direct personal experience is the recent launch of a youth court in Glasgow. Glasgow Sheriff Court has a long history of promoting problem-solving courts. It has had a drug court since 2001, a court which has been recognised and acclaimed internationally. Building on the success of that, we introduced an alcohol court which started sitting in February 2018. And to give you some idea of scale, in 2019, so that's the last pre-pandemic year as it were, a total of 167 people appeared in the alcohol court for the first time. And even last year, which I think as we all know was heavily impacted by the pandemic, 120 people appeared in the alcohol court for the first time, each benefiting from the court's problem-solving approach. From my perspective, after the successful launch of the alcohol court, the next obvious step was to pilot a youth court in Glasgow. And so I'll explain in a moment, that work began in 2019, like so many other things, has been impacted by recent events. The sentencing of young people is complex, challenging, and requires a more individualised approach. It's an approach which we are now facilitating in Glasgow by way of a problem-solving court. Analysis showed that on average in the first quarter of 2019, when we started the work to put the court in place, was that we had around 60 young people, and by that, in this context, I'm talking about those under the age of 21, appearing in Glasgow Sheriff Court each week. I could talk for a very long time in relation to the genesis of the court, however, time prevents me doing so, but put shortly, after a lot of work with the social work department in Glasgow, who've been incredibly supportive, the pandemic and 2 false starts, the court sat for the first time last Tuesday, that was on the 8th of June 2021. The court's presided over by the 11 summary sheriffs presently based in Glasgow. If business requires it, it's Tuesday to Friday each day. Apart from a Monday, Tuesday to Friday each week rather than each day. A young person must live within the Glasgow City Council boundaries. They must be under the age of 21 at the time of conviction. There's no restriction on the type of case that may be referred. So, for example, domestic offenders can be referred if that's not appropriate. The expectation is that the court will deal with summary cases only. However, solemn cases will be accommodated in exceptional circumstances. Cases that begin before a sheriff, including those where there has been a trial, can be referred to youth court if that's felt appropriate. Referral to the court will, however, always be a matter for the presiding sheriff or summary sheriff, in the same way as referrals to the drug and alcohol courts currently operate. Each summary sheriff retains cases referred from their own trials courts or remand courts, and referrals from sheriffs are allocated to the summary sheriffs according to the court programme and loadings. A youth court assessment report from social work is requested at the same time as the offender is referred to the court. Admission to the court will always be a matter for the summary sheriff presiding. We already have 18 young people referred to the court. We've been taking referrals since April. We await with interest how they get on. We're very optimistic that the problem-solving approach of the court and the intensive support which will be provided by the social work department will produce positive outcomes. Thank you very much. I think maybe.
Sheriff Brown, I've unmuted you, so.
Yes, thank you. Well, as a summary sheriff sitting at Glasgow Sheriff Court, I'm going to talk about the experience of a sentencer when dealing with young people and the challenges this poses. I think the first thing worth noting is that sentencers already approach the sentencing of those under 21 in a different way from the sentencing of fully mature adults. There are, of course, a number of reasons for this. For example, in terms of Section 207 of the Criminal Procedure Scotland Act 1995, the law gives certain protections to young people under the age of 21 when it comes to sentencing, such as the fact that a custodial sentence cannot be imposed on a person who's under 21 unless the court is of the opinion that no other method of dealing with them is appropriate. Anyone under 21 cannot be sent to an adult prison. And in some circumstances, the court can seek the advice of the children's hearing in relation to young people under 18 and regularly does so. So aside from those statutory provisions, the High Court has also provided guidance about the sentencing of children and young people, which sentencers are required to follow. This is set out in a number of High Court judgments and appeals against sentence. I think the first key judgment that I would mention is the 2003 case of Kane against Her Majesty's Advocate. In that case, a 2-year custodial sentence was imposed on a 16-year-old convicted of robbery. That sentence was quashed in favour of a non-custodial sentence at appeal. And in giving the court's decision, the Lord Justice Clerk, Lord Gill, at the time said that there is more to sentencing than sending messages to society, particularly in the case of a young offender. The court has to consider the personal circumstances of such an offender, his home background, the extent to which he may not be solely responsible for his behavioural problems, and the opportunities that a non-custodial sentence may give for rehabilitation before he becomes trapped in the cycle of crime. So right away, you can see 4 principles are set out to be developed there. Those are an emphasis on looking at personal circumstances, home background, degree of responsibility, and of course, an emphasis on rehabilitation. The next key judgment I think it's worth mentioning is Gregg against Her Majesty's Advocate from 2012. In that case, the court invoked Articles 3.1 and 40 of the UNCRC when it noted that in sentencing a person who's a child, regard must be had to the best interests of that child as a primary consideration. Regard must be also had to the desirability of the child's reintegration into society. The court emphasised these points again in the 2016 case of McCormick against Her Majesty's Advocate, where it noted that while it was not necessarily illegitimate in sentencing a child, to consider the sentence which an adult offender might attract and then reduce it to reflect the age and immaturity of the child. In doing so, the court must have regard to the 3 important factors of the welfare of the child offender, the need to facilitate their rehabilitation, and their reintegration into society. So you can see the way these principles have been developed. The final key judgment is that of Smart against Her Majesty's Advocate in 2016, when the Lord Justice Clerk, Lady Dorrian, said it is always necessary to consider the individual context in which the youth of an offender would be a very important consideration. Even a very serious offence, which in an adult might require a custodial sentence, might not do so in relation to a young person. So as the appeal court has made clear, then sentencing a child or a young person is not simply a matter of applying a percentage reduction to the sentence that a fully mature adult would get. As a sentencer, I'm aware that it requires me to give detailed consideration to the factors highlighted in these appeal court cases and of the need to consider how to address underlying causes of offending behaviour in the young people who appeared before me. So, there being a clear and established body of case law and statutory protection already in place, the question may be asked as to why a guideline on the sentencing of young people is necessary. And the answer to that, of course, lies in the Council's statutory objectives, which include a requirement to promote greater awareness and understanding of sentencing policy and practice. So it's hoped that a key benefit of the guideline and of the sentencing process guideline you've heard about will be the explanatory effect to enhance understanding of sentencing in the eyes of the public. This will be an important step, hopefully, in raising public awareness and understanding of why sentencers take a different approach in relation to the sentencing of young people. And it's also hoped the guideline will benefit sentencers by distilling the key factors we need to consider into a concise and accessible document. It will also be of assistance to practitioners, and one can easily envisage the assistance that would give in a busy court in terms of having a document that enshrines these principles. However, perhaps more important for sentencers is the fact that the guideline draws on the latest research and evidence around cognitive development, and particularly how this can be affected by experiences of trauma and adversity. I should say that it's already well within judicial knowledge that many young people who have committed offences have high levels of adverse childhood experiences, such as emotional, physical and sexual abuse, neglect, domestic violence and household substance misuse. They're also more likely than the general population to have experience of trauma, including higher than average experience of traumatic bereavement. But the guideline will highlight the need to consider the impact of these experiences on the level of a young person's maturity, and therefore, critically, on the level from the point of view of sentencing, on the level of their culpability for an offence. And the mention of that word culpability takes me to my final point. I want to say something about one of the most challenging aspects of sentencing, and that concerns the way in which courts assess the seriousness of an offence, including consideration of the impact on victims. As the sentencing process guideline will set out, the seriousness of an offence is normally evaluated by taking into account two main factors. Firstly, the culpability or blameworthiness of the person who has offended, and as I've just indicated, the level of culpability for a young person will indeed be considered in the light of the experiences they have had. And secondly, the level of harm caused by the offence. So this includes the impact on any victims, and it's a fundamental part of the overall assessment of the seriousness of an offence. The court's assessment of the level of harm is not affected by the sentencing young people guideline. That is to say, even though a young person's lack of maturity may make them less blameworthy, this does not change the assessment of harm. So sentencers must also, by law, have regard to any victim statement when determining a sentence, to the extent that they consider the information in that statement to be relevant to the offence. So the particular challenge in all of this comes where the perpetrator and the victim of an offence are both young people. As the Lord Justice Clerk said earlier on, this is commonly the case in respect of sexual offences. It's also the case that many of the issues that affect young people who offend, such as I've mentioned, trauma and adverse childhood experiences, also affect victims who are young people. So it's therefore difficult to impose sentences in cases involving children and young people which balance the rights and interests of all of those involved, victims, offenders, families, and the community or society more generally. And sometimes these interests can overlap, sometimes they can appear to be at odds with one another, and sometimes they can almost appear to be irreconcilable. And the difficult and complex task for sentencers is to try to reconcile these in a way which reaches a fair and proportionate balance of the competing interests of the individuals involved and of the community or society. And it's the Council's hope that by creating the Sentencing Young People Guideline and in due course offence-specific guidelines such as guidelines on sexual offences, we can offer some assistance in achieving this balance. Thank you very much.
Thank you very much, Sheriff Brown. Can I pass over to David Harvie, please?
Good afternoon, everyone. At its first meeting in December 2015, the Council agreed to carry out a public consultation on each of its draft guidelines. The public consultation on the Sentencing Young People Guideline is the third of these exercises which we've held. But rather than delay because of the pandemic, we kept our consultation open for 6 months as opposed to the usual 3, and consulted over spring and summer of 2020. That was fruitful. It produced 280 responses, 239 from individuals and 41 from organisations. This is by some margin the largest number of responses we've received to a consultation, and it's fair to say that this is our highest profile guideline to date, and it has sparked a great deal of comment and debate. As the Lord Justice Clerk noted earlier, we've recently considered those responses, and we intend to publish those imminently alongside the consultation analysis, the University of the West of Scotland research mentioned by the Sheriff Principal, and our report on the consultation exercise. And in that report, we will set out our final decisions on the content of the guideline. Without in any way wishing to preempt our report, what is striking about the results of the consultation is just how much of a divergence in views there was between organisations and between individuals. So before I talk about why that might be, let me be clear that we're very grateful to everyone who took the time to respond, and every response that we received has been carefully considered. I also want to be clear that when I refer to responses from individuals, I don't mean that there was some kind of monolithic response. We received a number of very, very thoughtful responses from individuals who either work within or have experience of the criminal justice system, perhaps including some of you who are here today, and you have our thanks. However, many of the individuals who responded were members of the public who it was clear from the responses didn't appear to have any great familiarity with the detail of our proposals. And it's really some of those responses that I'm going to focus on. In general, organisations were very supportive of the draft guideline and particularly welcomed its evidence-based, person-centred approach. Organisational responses showed an in-depth awareness and understanding of current sentencing policy and practice and the evidence base for the guideline. And they generally commented on the proposals in greater detail than individual responses. In contrast, many of the individuals expressed strong opposition to specific aspects of the draft guideline. The independently conducted consultation analysis suggests that the views of some individuals in some instances might have to be treated with some caution because they appeared not to fully understand the current statutory framework behind the provisions suggested in the draft guideline. In particular, there were quite different levels of awareness between individuals and organisations around the existing laws that applies to young people within the criminal justice system, what contributes to offending behaviour among young people, and what might contribute to reoffending. Another important fact that many individuals were unaware of, although this may perhaps be unsurprising, is that more young people under the age of 18 are referred to the children's hearing system on offence grounds than are convicted of an offence in the criminal courts. It may not be a surprise then to learn that the organisations are supportive of the general thrust of the guideline as consulted on and its application to persons under 25. They agreed that the lack of maturity in those under that age, the effect of adverse childhood experiences and trauma on a young person's development, and the greater capacity of young people to change justified a different approach to that adopted in the sentencing of older people. That wasn't the case among many individual respondents. a proportion of them appeared to mistakenly believe that we were proposing that those under the age of 25 should be treated as children or should not receive custodial sentences. We're aware of some reporting which gave that impression at the time and which we believe may have influenced some of the responses in the consultation. So there is some evidence of a gap in understanding between practitioners and professionals within the criminal justice system on the one hand and the general public on the other. Again, this shouldn't perhaps become as a surprise to any of us. Criminal justice and sentencing, as many of us know, are highly complex areas which can be difficult for professionals, let alone lay people. But it should be a concern for all of us. We all have an interest in ensuring public understanding and confidence in the criminal justice system. It can be hard to unpick precisely what public opinion on these matters is. Views expressed in other areas of our work, I'll pick that up again. It can be hard to unpick precisely what public opinion on these matters is. Views expressed in other areas of our work seem to contrast with those received during the public consultation, and I'll go on to talk a little about that a little later. But we know that understanding is inextricably linked with perceptions of and confidence in the justice system. As Sheriff Brown has already mentioned, one of the Council's statutory objectives is to promote greater awareness and understanding of sentencing policy and practice. Our guidelines will play an important role in that. The three general guidelines that we've discussed this morning explain clearly, for the first time in a Scottish context, how sentencing decisions are made and the factors that are considered. But in and of themselves, those guidelines are not enough. In the short term, it's clear that the issues of sentencing young people guideline aims to address require further explanation by the Council. And in particular, we will seek to raise awareness of how younger people are currently dealt with in the criminal justice system and to promote a better understanding of the reasons for offending in young people and the role of sentencing in addressing these. In a nationally representative survey of public perceptions to sentencing, which was carried out by Ipsos Mori on behalf of respondents, on our behalf, respondents were asked for their views on the single most important things that the Scottish courts should be trying to achieve when sentencing in general and when sentencing young people. For sentencing in general, 50% of respondents thought that protecting the public was most important. However, for sentencing young people, 54% thought that rehabilitation was the single most important factor. A number of research projects that we've commissioned into public attitudes replicate the findings of other jurisdictions, namely that when surveyed, people express a broad perception of sentencing as lenient. But when they consider the matter in more detail and with more information, opinions change, with members of the public often imposing sentences in line with judges when carrying out exercises based on real-world scenarios. So while there is a gap in understanding, it's not an unbridgeable one. This is where we hope that some of you can help. In the Council's view, the Sentencing Young People Guideline will make a difference. It will promote an approach aimed at rehabilitation and securing better outcomes for individuals and the community by reducing offending. We hope and expect that when we publish our consultation report on Sentencing Young People Guideline, that there will be a public dialogue on our proposals. We are particularly interested in exploring opportunities to work with other organisations, both around this guideline and future offence guidelines. And we're open to suggestions about how best to do that and how best we can help to increase public knowledge and understanding, whether that's through participating in your events or collaborating on articles, blogs, videos, whatever. Let us know what you think, and if you want to discuss this further, please feel free to contact us after today's workshop. I think all of us here today understand the issues affecting young people involved with the criminal justice system. The Sentencing Young People Guideline won't solve all of these, but we think it's an important step forward, and in our view, it will bring positive benefits for all. Thanks very much.
Thank you very much to all our panelists. I can't tell you how difficult it is to get all of these people in the same room together. So it's a reflection of how important it is, this work, and engagement with everyone that's involved in delivering youth justice.